Good afternoon, everyone. My name is Mel Shaw. It is my pleasure to serve as chair of the ABA General Practice Solo and Small Firm section for 2025-2026. And it is also my pleasure to welcome you to today's program. GP Solo endeavors to bring all of its members programming that deals with the real issues that we confront as lawyers and those that our clients face. And so today's program will delve into immigration issues, particularly how we can continue to represent our clients in that space, how AI is changing that dynamic when it comes to advocacy for our clients in the district court level, appellate court level, but also how we may maintain our clients' privacies and be the best advocates as we can. And so it is my pleasure to have three panelists here today, Eric, Enid, and Emily, and who will be introduced by Lourdes Fuentes, who it is one of our diversity fellows for this year. And I will leave it to Lourdes to do further introductions. Again, welcome to today's program.
Thank you. Thank you, Melvin. And thank you to all of the participants. My name is Lourdes Fuentes. I am a member of the ABA GP Solo Division and a diversity fellow. I'm also an ABA woman of legal tech. My interest in immigration really arises from a brief tenure I had as a CEO of an immigration law firm. I am the current CEO of Carter Legal, which is a legal operations and practice management consultancy. And I am very pleased to be joined today by immigration attorneys with a lot of experience in the area. And they will be sharing with all of you their views of the world as it is right now. And I'm sure that we'll learn a lot. So we are going to start with introductions. The program really is designed to provide a practical, equity-focused overview of the immigration landscape. And we're going to touch upon a number of topics, including enforcement trends, detention advocacy, removal, appellate strategy, ethics, and AI, which I think is in everyone's sort of top of mind. The program is 90 minutes long, so I may interrupt our panelists from time to time just to keep us on time. Apologies in advance for that. So let's begin with our panelists introducing themselves. Can we begin with you, Enid?
Sure. Good afternoon. My name is Enid Rivera. I'm the founder and managing attorney at Enid Rivera Immigration Law Firm. We started in 2023 after we've been practicing law for 27 years. But for the last 11 years, we've been practicing only immigration law here in Virginia.
Emily?
Thank you so much. Hi, everybody. Welcome. My name is Emily Amara Gordon. I have my own immigration and criminal defense practice in the Boston area. I opened it in 2013. The day after I became a lawyer. My law school, which I currently am an adjunct faculty at, is graduating today on May 15th, if you're watching this as a recording. So it's very nostalgic to be here today with all of you and see everything come full circle. At the ABA, I'm a member of the Commission on Immigration. I am on counsel and various other committees of the Law Practice Division. I'm also a member of the Judicial Ethics and Professionalism Committee, and I'm a fellow of the American Bar Foundation. When I'm not practicing law, I love legal technology, and I have a consulting company called Amara Innovation. So look forward to the conversation today. Thank you, everyone.
Great. Eric?
Hi, everybody. Good afternoon. My name is Eric Suarez. I'm the managing attorney at GF Immigration Law. I've been an immigration advocate now for 12 years. I've been focusing on advocacy before the Immigration Court, advocacy before USCIS, and the appellate courts. I've been able to successfully litigate a case before the Fourth Circuit Court of Appeals. That's now a published decision for our clients. And really, immigration is not something I intended to go into, but it's something that found me, and it's a passion that has driven my professional success for the last 12 years. And changing lives of our clients at every step along the way. So thank you, Lourdes, and to the ABA for having us here today.
Great, awesome. All right, so let's dive right into our first topic, which is enforcement through an equity lens. All right, so as we all know, immigration enforcement, it is not just administrative, right? It affects family stability, community trust, access to justice, and it also intersects with racial disparities. So one of the questions that I have for our panel, and Anit, I will start with you, is about today's sort of environment and what enforcement trends you're seeing right now that may be of interest to our audience. And I should point out that when we were sort of advertising this webinar, one of the things that I wanted people to understand was that it was not only for immigration attorneys, but it's for all of us out there that are interested in the subject, that maybe in other types of practices that we see immigration issues pop up and we need to know how to address them and how to direct them properly. And also for those of us that just want to volunteer. So, I mean, I want you to keep that context in mind because not everyone that will be listening to this, either the live version of this or in on demand later, may be an immigration attorney. So, with that in mind, Anit, what sort of trends are you seeing today that impact enforcement?
I would like to begin by discussing some recent changes and things that we're going to see now within the immigration court system will affect pro se respondents or unrepresented respondents. And it looks like now the judges are going to have a high volume dockets, and they're talking about 100 master calendar hearings in just one session for pro se respondents, which I believe is crazy. Some of the practitioners are calling this the mega master calendar hearings. And the purpose behind this is bringing, and they're saying it's going to be in person as well. So we're going to have 100 people, maybe, if they go to the court, before the immigration judge. And the staff are going to be handling the EOIR 33, which is the form for change of address, because they want to make sure that all the respondents are filing the correct address or at least having the right address on file. Starting in July, and this is something that I heard, many of the pro se calendar here, master calendar hearings are going to be moved up, meaning that if they don't have the address, the current address on the file, they are not going to receive the notice for those mega master calendar hearings, meaning they're going to end up with an order of removal. And I believe that for practitioners, we should advise clients first, they should not go to court without representative, without attorney since day one. And I believe this is because they're used to go without attorney to the first master hearing. And this is very common. If every time you have a client, they say, no, I heard that I can go without an attorney to my first master calendar hearing, and then I will be advised to come to the second master calendar hearing with an attorney. And I believe this is a new immigration enforcement within the immigration court system to try to bring them all together. I don't know. I would believe that many of the respondents are not going to appear in court. They're going to be afraid, but most of them are going to miss the master hearing just because they didn't have a current address on file.
Yeah,
so this is concerning.
Right. That seems like a huge problem. I mean, I don't even understand how that is going to be enforced equitably, but very, very interesting. it's such an important question. I want to hear from our other panelists, both Emily and Eric, about this enforcement trends. Emily, are you seeing something in your jurisdiction that is equally concerning or around the same along the same lines?
So I think what Anid just was talking about is right before I started this session, the Commission on Immigration is holding their second part of their spring meeting in DC. So I was there remotely and we were just discussing this. So not locally, but nationally, it's sounding like this is getting repeated in all different credible channels of immigration law. So this particular policy, I think because it's a future estimation, we're not seeing it yet. I mean, I do think on that question, local practice is huge, right? So I can't speak to this as a local practitioner since I'm on the other side of the country. And from January to April, I wish I was in California, in Southern California, but I believe anyone's here. Wasn't there an issue in, was it San Diego? We were all just there for this joint spring meeting with the ABA, but I believe it was San Diego that had an issue where people were being arrested more frequently. And I apologize if I'm getting the city wrong, but in court where they would show up, the case would be terminated. And then, so if you don't have an active case in immigration court, ICE would then have jurisdiction to arrest and I have to, at least from their perspective, I'm saying this is legal, worry about having to navigate the removal proceedings since it's terminated. And so I believe, and again, I apologize since it's not my local area, but that was happening frequently, I believe in San Diego or in California somewhere. So that's huge. Whereas if I advise a client of that and it's not happening in Boston, and the client, we would never say don't go to court, but the client takes that intel and does what they do with it, that can have a drastic consequence when it's not happening, hypothetically, it's not happening here, right? So I would just say to that question, I think no matter where you are, knowing the local practice, and if I, in this hypothetical scenario, have a client in San Diego, I better be calling somebody who knows that up, down, and sideways, because the weather forecast there, if you're telling the clients it's going to be 75 degrees and sunny and they don't pack a winter coat, and then they show up and it's bad analogy. They pack a winter coat and no shorts, or I'm clearly coming from a New England winter. It's going to be an awful experience, to put it lightly, right? Clearly that's a very trivial example, but I think knowing what's going on, and even someone like me, these days I practice much more criminal defense work. And so if, I have a few of my special immigrant juvenile clients who are still navigating immigration court, or they have a hearing coming up. And just yet last night, I was at a local AILA New England meeting asking, my colleagues were kind enough to give me the intel on, hey, what's this judge doing? What's going on? What do you recommend? Because even putting aside the court, we have 2 courts in our area, which I know is not a lot for some jurisdictions. And depending on the judge, it's so different. So I would you want to talk to people who were there and were there recently, just to give the analogy, get the weather forecast to know what's going on, because it's crucial and it can drastically affect what happens to your clients and the decisions they make.
Yeah, that's a very good tip. Eric, down in Florida, what are you seeing are the enforcement trends that are most relevant to immigration practitioners and those that want to know what's going on?
Yeah, I mean, I think what Emily was mentioning about individuals being detained in immigration court was happening here. I know it was happening in Anid's area too, because I worked in Maryland for 10 years and we had a lot of contacts still in the area were telling me people were getting detained in court. And I think that's one of the most troubling trends. There's a lot of things that as advocates for the immigrant community, we are troubled by what's going on. Individuals who are being detained without a criminal record for really no reason at all. They're being detained at traffic stops for no apparent reason. They're being detained at ICE check-ins. But the worst one of all is when they're detained in immigration court, because they're following the process that the law has established for them to seek the benefit that they are claiming. And they're going to court. The judges are oftentimes working with the department, or at least listening to what the department is saying when the department requests for termination in these cases, knowing full well that the client was going to go outside and get detained. And that was happening here in Miami all the time. And you could hear the screams of family outside of the court as their relatives were getting picked up and detained right as the judge had terminated the case and they walked out of the court. That is heartbreaking to see that happening to people who are going through the process that's established. If you have a case before the judge or before the court, you should be able to take your case before the court and make it, and have a good advocate on your behalf to go forward and fight that case for you. And so of all of the things that we've seen, and of all of the enforcement trends that have really been moving towards the direction of over detention, this is by far the worst one. Thankfully, it down here, at least in the last few months, has not been happening as much, but we had reports of it happening even a couple of weeks ago, still here in Miami. Not to the same extent, but still happening.
So I was at the spring ABA conference in San Diego, and about 10 of us went to immigration court to observe the master calendar hearing one afternoon. And there were about 10 of us. We signed up, we went in the elevator to the floor. And as the elevator doors opened, there were two ICE officers right there, which shocked me. And it was very sort of like, I mean, intimidating for 10 lawyers is really not the right word, but shocking to see them there. And when I was talking to one of the bailiffs, he was telling me that a couple of weeks ago, they were arresting people even before they went into their hearing, which I'm not sure how correct that is, but it sounds really worrisome and really deters people from following the process to get their status correct. So something to think about. As we talk about enforcement, one of the things I wanted Emily to touch upon, because as she said, she does a lot of criminal work, is what should non-immigration lawyers understand about how state level or criminal offenses can trigger federal immigration consequences.
Thanks, Lourdes. I appreciate it. If I just want to follow up and give you your flowers and thank you for going to the observation project in San Diego. It's incredibly important. And again, we were just talking about this at the Immigration Commission. Anyone who's listening who'd like to get involved, who'd like to volunteer with what Anid said with this projection of master calendar hearings with potentially, I think they're saying 100 respondents and just at least these changes coming up. We're really looking for people to sign up for the program. So if you're interested, you can get my info here, just find me or anyone on the Immigration Commission. And I think there's a flyer there with all the material. So somehow you'll find us. We're really looking for volunteers. You don't have to be an immigration lawyer to observe, because
you don't even have to be a lawyer.
Yeah, good point. And
really
because the theory is if they are going to remove people in absentia when people aren't there and there's no one there to witness it, they're more likely to get away with shenanigans, to put it lightly, right? So we have to hold them accountable to make sure that if no one's there or somebody doesn't have an attorney and thinks that this is what's supposed to happen or speaks a different language than the judge, that somebody's there to say, hold on a second, you can't do this. So we're looking for people. So I hear so often people say, I want to help. This is a great way to help and actually make a difference, and help future litigants and as well as those who will experience this now. So back to the question that you had, that's a whole law school class. I'll say, it's so tricky. So the intersection, for those aren't familiar with the area, the intersection of immigration and criminal law, we all call Crimmigration. And it is, at least in my opinion, one of the more complicated, difficult, potentially intimidating areas of law to navigate, and even all of that within immigration, right? It's tricky. And I think one of the reasons it's so difficult is because the criminal portion of it varies by state. It varies by, even in Massachusetts, we have, on the state level, we have district court and we have superior court. There's different rules in superior court and things that happen than in district court, right? So it just understanding the criminal piece, then how that fits into immigration and federal law can be a labyrinth. My kind of like quick tips are, if you get a case like that, particularly if the criminal case is still open, so the future can still be determined, and you aren't incredibly comfortable with criminal law, please get an opinion. And I say this to criminal defense lawyers and immigration lawyers. If you're a criminal defense lawyer and your client is not a U.S. citizen, please figure out and ask, this is something that you get a second opinion on, or a third, on what we call collateral immigration consequences. And because it's so complicated, and the consequences are so dire. And then on the immigration side, if you have a case, you say, oh, this is easy, or this is not a serious charge, and you don't really practice criminal law, this is the time to co-counsel or to get an opinion. I also always recommend, putting on my criminal defense hat, and sometimes the hats look different. With criminal law, you acting quickly, acting early can make a world of a difference. So if you have a client who calls you and says, I got a notice to go to court, or I think I'm going to be arrested, or my brother's at the station, there's a whole, just like any other area of law, there's a paperwork process. And so if you can intervene early on in that paperwork process, depending on what's going on, you may be able to mitigate the consequences even before the case starts. So I won't go into too much detail, because what I'm referring to for my Massachusetts lawyers, we have something called the clerk's hearing, and that's a way to resolve a case before the client's arraigned or charged. So knowing, I'm sure every state has all of these little pockets, and if that pocket is available to your client, knowing that and intervening early can make a world of difference. And when you get the phone call is not the time to figure out who's the criminal defense lawyer I'm going to call. I'd say have that all ready to go. Go hang out with some criminal defense lawyers, make some friends, so you're ready to go. And also on that, at least here in Mass, criminal law can be very, it's very court specific and very regional. And so if you're in a bigger state or even a smaller state like Massachusetts, having a criminal defense lawyer practices in Western Mass, Eastern Mass is really, really helpful. Also, they're there, so they can get there faster. So I really recommend diversifying your contacts and referral networks. In terms of going to the other side and pleading, even I just did a plea this Monday. It was a very long process. It was somebody with serious immigration issues, and we really took our time with my client's consent. There was strategy there to really work out a resolution that made the most sense for him. And I frankly think was an excellent resolution given the circumstances. But we were like cuidado, I always say, like, take a minute, be careful. And there is often sometimes an urgency to rush, and maybe typically in court, you may, let's resolve this case. It's not that serious. But if somebody is not a U.S. citizen and is facing any kind of criminal case, please take your time. And if you can do that strategically, luckily for my client, many of his court appearances, presence was waived. So his risk of being detained was a little bit lower versus having to go to court every single time. So we came up with solutions that mitigated his risks and also increased the chance of him getting a resolution that I frankly think was the best possible resolution for the situation. Finally, I'll just kind of like slip this in, some common sense tips. I tell my clients, whether they have immigration issues or not, like, wear your best Sunday clothes, right, to court. Like, this is not the time to I'm all for being an artist and expression, but, neutral colors. You don't want to stand out. I have had clients walk by ICE in a courthouse and ICE didn't notice them. I say, don't talk too much in the hallway. Don't be on the phone. Don't draw attention to yourself. Wear clothes like professional clothes if you have them and can afford them, and do the best you can, because it could make a world of difference so that you're hopefully not targeted for an arrest when ICE may be there for person A, but you all of a sudden become a collateral arrest because ICE may have profiled you and noticed you. So all of these levels of strategies, I think we often think like, let's put the plea together so it's not deportable or it's not an admissible offense. But there's these pieces that can make a huge difference in somebody's life and hopefully mitigate the chances of being arrested and detained.
Right. I guess it's always good to know what you know, but also know what you don't know and seek advice. All right. So moving on to, I guess, a related topic, which is due process in detention. I think that creates one of the most significant concerns in the immigration system right now, especially when access to counsel may be limited by distance, logistics, communication barriers, etc. So, Eric, what kind of tips do you have for the audience about practical building blocks to build a strong hearing or custody strategy?
Yeah, that's an incredibly important question now, as many more people have been detained by ICE and now are in custody. We saw a few months ago that the government tried to change the approach to detention, immigration detention. They wanted to detain most immigrants under a provision of the Immigration and Nationality Act that prevented them from being eligible for bond, and thus not being eligible to have their custody reconsidered by an immigration judge. So if ICE determined that they weren't going to release them and they weren't releasing anybody, they would not be eligible for release by an immigration judge. We've seen that start changing over the last few months, and now we have the Ninth Circuit, the 11th Circuit, I think the Second Circuit, and the Sixth Circuit most recently, who've all come out and said that this interpretation that the government tried a few months ago to put everybody under that what we call INA 235 detention, which makes them ineligible for bond, now has been challenged. And so in those cases, now here in Miami, we're able to do that. In Florida and the 11th Circuit, we're able to do that. We're able to challenge these cases. So the first thing we got to look at is whether the person is even eligible for bond based on where they're being detained. And then we need to look at a whole host of things, right? Including their ties to the community, including their what we call flight risk. How likely are they to go back to court, whether they're a danger to the community. We need to look at criminal history. But increasingly, over the last few months and weeks, we've seen the judges, especially in these jurisdictions, start focusing on eligibility for relief before the court by considering that first before they even consider whether or not they're going to grant a bond motion. So if somebody's going to fight an asylum case, we got to start thinking from the moment that they get detained, whether or not this is going to be a viable asylum claim, because we are going to have to make that argument to the judge as we're in bond proceedings, which are supposed to be separate and apart, completely separate and apart from removal proceedings where we're supposed to fight their case. And so that's made it 10 times harder now, on top of the fact that we're considering these private immigration detention facilities, which are all different. They have varied all over the place in how we can even get a hold of our clients. We've had cases where the client has had to pay thousands of dollars just to reach us as their lawyer. And so that created a whole host of challenges for practitioners across the board that we got to begin to think about, where just a couple of years ago, we never had to think about that.
So if you want to challenge, and this is sort of an interesting question, due process violations, but your client can't pay for that, then what happens? Is that one of the reasons why there aren't more challenges going up through the right levels?
Of course. So we need pro bono advocacy at every step along the way, but these cases are incredibly challenging to fight before the court. And the reality is, and you touched on this subject earlier too, it's the speed with which they're moving clients all over the place and detaining clients, right? And these hearings too. We've had cases that are literally the individual hearing is rushed through to ensure that the client has their day in court, quote unquote, as quickly as possible. But in reality, where we might have before had a 3-hour hearing, we're having it in an hour and a half. Well, we might have had a month or a month and a half or a little bit more sometimes to consider a case, to prepare evidence, to prepare ourselves for fighting this case. We have weeks, and so that's a big challenge. It's not just a financial component for the clients too, but it's this element of speed that the court is moving in now, especially for the detained cases. And then the strategy that they've used of moving people outside of the area with which, where they're living and residing, where their family is, and we've seen that happen all over the place, where they're detained in Maryland and they'll be sent to Texas, within a day of being detained, or being sent to Louisiana or other jurisdictions that might not be as favorable, or might be placed in horrible immigration detention center conditions. The family doesn't know where they are. It's hard for even the attorney to figure out where the heck they are, at least for the time being. And that creates an incredibly frustrating process because we can't even get a hold of our clients for a day or two as the case is moving along, and that's really difficult.
Yeah, it sounds like it. I don't know whether you have something to add to that in relation to your jurisdictions, what you're seeing in your area. But I also wanted to ask you specifically, what type of evidence you think is very effective to establish community ties, credibility, et cetera?
Yes, I don't do a lot of detainees here. However, I would like to add here in Virginia, I was doing a bond request hearing, and most of the hearings, most of the requests were denied. And were denied and for lack of jurisdiction, but in the alternative, they found the respondent a flight risk, and also if there's a criminal record, danger to the community. And that's something that we're seeing. Like, and I was discussing this with a colleague, and I was trying to get any advice about habeas in this type of cases. But however, the judges are saying, yes, I don't have jurisdiction, but in the alternative, and this is not good when it is when we're filing for habeas, because even if I have jurisdiction, I would deny it just because he's a flight risk. In terms of evidence for we have, and I wanted to add this, we had this particular case that the immigration judge granted the bond. He said that he had jurisdiction, but what really made the difference was the asylum application was already filed. We filed the asylum application at the master file, and then we filed for bond. And for him, that was a good strategy. He said at least he has an application that has been filed and it is pending. So the asylum was granted, and I think it was a few months ago where they were granting and they were not denying just because of jurisdiction. But when we file a request for bond and when it comes to evidence, the respondent must have a fixed address. I always ask for evidence of that fixed address. I wanna make sure that the court knows that he has been living in a certain place, and that it could be a mailing, it could be lease agreement, it could be mortgage, or whatever they have to prove that they have been in that address for a long time. We usually include evidence of a good moral character. That comes from the church, that comes from the sports, that comes from the school, neighbors, how many ties they have with the community, and how many ties they have to the United States. If they have US citizen children, I want those birth certificates. If they have family members with legal status, that will give the court evidence that they're not a flight risk, right? Because they don't want to leave because their children is here, all the ties, their life is here, right? So that's part of the evidence that we usually try to get. Taxes. I try to file taxes. He's complying with the law. He's filing his taxes. So that goes to moral character as well. Exactly. And so those are pretty much good evidence when it comes to a bond request. And also, very important, as Eric said, the relief. That's really important. If the person if that individual doesn't have a relief, it's going to be found as a flight risk, because why am I going to grant a bond for someone who's not eligible for anything?
Right. As I hear all of you talking, one of the things that strikes me the most, and what I have seen anecdotally, is how time-consuming and important it is to find effective immigration counsel. Because to get all of the information that all of you are talking about and to connect all of the dots that you guys are talking about takes not only knowledge of immigration law, but a lot of time and effort from the attorney, from the staff, from the paralegal. And I think that is something that I want to point out to everyone in the audience, those that want to get into this practice and those that are considering pro bono work, is that it is not an easy process. And you have to have your heart has to be in it as well. And I really am always so impressed when I hear all of you talking about your clients and your cases, because I know that you oftentimes do not get paid for all of the hard work that you put in, the extra mile that it takes to do this work. So even, I mean, the sad reality is that even if the clients are not detained, procedural delays can become a hardship, as well. So one of the topics that we wanted to talk about was backlog, to the extent that you have it in your jurisdictions or not. So I want to start talking to all of you about what are you seeing in your specific jurisdictions with respect to, is there a backlog? Not, how do you address that? Emily?
Sure. Is it okay if I talk about the backlog for special immigrant juvenile cases and then
Of
how that's
course.
affecting removal? Okay. So thank you. So I do a lot of special immigrant juvenile status visas, which are it's a pathway to a green card for, just give a quick, it's children under 21 who have been abandoned, abused, and or neglected. So you need one of the three. You can have two or three by one or both parents. And it's in their best interest to continue residing in the United States. And I particularly will say in the Commonwealth of Massachusetts, because all those findings need to be made by in Mass, we say family and probate court judge. So in your jurisdiction, it may be juvenile court, it can be juvenile in Mass. We typically go to family court. And that's also state specific. But that first piece is the state piece, and then eventually you deal with immigration. And so I represent a lot of children and have for many years. And so I have to explain this to young people, teenagers, and their families. And I say that oftentimes there's three steps or three pockets because they don't always happen. Sometimes they happen at the same time, and sometimes it's one after the other in order. So you go to family court, and then you file, once you have we call it the predicate order from family court, you file with USCIS and I-360. So that's like your I-130. It's the initial form that's filed before you file for the green card. The problem is that there is a backlog. So there's something called the visa bulletin. Again, another, that could be one class in law school, but the government there's different categories for family-based, employment-based. And so depending on where you fall and sometimes where you were born, it affects how long you have to wait to get a green card. And some of these waits are very, very, very long. Going back to special immigrant juvenile kids, in recent years, I don't know the exact number, but my own experience, I'll say, about 5, 6, 7 years, there's been an incredible backlog. It has gotten a little better recently. At times it peaked for the Northern Triangle. And so the problem is, we talked about, there's all these different things happening. Sometimes they're happening concurrently, sometimes not. And so these kids are waiting. So they went to family court. Judge said they're SIJ eligible. They file their I-360, Homeland Security saying approved, you're a special immigrant juvenile. But they can't apply for a green card yet because there's such a wait. And I don't even know if I want to say out loud how long I've been representing some of my oldest. I call them like my pack of five. I have 5 kids that I started with. Their green cards are all pending. We're still waiting. And so the problem is, you're hearing my wonderful co-presenters here talking about, judges they're rushing things, or there's a lack of due process in some courts and a lot of courts. And it's, well, what's your case? You have to present now. If you don't have a relief available, your bond can be denied. So there's all these different pieces happening. And these poor kids did everything they were supposed to do. They went through this whole very stressful process, talking about incredibly difficult facts of their life, often incredibly stressful and upsetting, traumatic facts. And then their I-360 is approved, and they're courageous, and they go through all of that. And then they have to wait countless years to get a green card. Meanwhile, if they're in immigration court, and they're in a way you want a backlog for these kids because of the way because the visa bulletins backlog, you don't want court to be too fast so that they're not removed. And so for courts that are speeding things up or getting rid of options, we had things called the status docket or term. A lot of my kids before this current administration, I was concerned that this administration may win. And so I was terminating left and right when that was still an option. And it may still be in some cases. For my I call my kids. I don't have biological kids. These are my kids. I was terminating them when they had approved I-360s to get them out of court because I didn't want them in court, adjust them before USCIS. So I'll just say this is my own individual practice, my law practices story on the backlog sometimes is awful. And sometimes, depending on which context, one bad backlog makes the other backlog good, right? If you can't find another remedy in immigration court. So it's a mess. It's very frustrating when some people will say, well, they should just put in their papers or say they should just do it the way they're supposed to do it. What about my kids who have been fighting since we're going on decades sometimes, like 10 years. And now these kids have children. And they're just waiting for their green card. And I won't even go into deferred action and how their work authorization is lapsing. And I have a client who works at Target and she's going to lose her job any day now because her deferred action wasn't extended. Those who know. And I applied for work authorization with her green card, and that in other times that would have been approved months ago. And it's just sitting there. And now she may not be able to work at Target and provide for a little baby. Like, welcome to the backlog and the labyrinth. So that's my story that's my take on the backlog. And unfortunately, these wait times can ruin people's lives, despite all of their efforts.
Right. But I take your point that it can be good and it can be bad. All right. So moving on, because we don't have a lot of time left and there are a few more topics that we want to cover. I want to talk about appellate practice. And Eric, I know that you're quite an expert on this. So tell us a little bit about appellate practice and what makes a good appeal versus a weak one, et cetera.
So in immigration court, when you lose before the immigration judge, you have 30 days to file an appeal to the Board of Immigration Appeals. That board is still under the Department of Justice. They still report to the Attorney General and the Executive Office of Immigration Review. So they're under the same umbrella as the immigration judges. And for a very long time, when I started doing this, you could fight a case before the BIA and have a really good argument and prove that the judge made an incorrect decision and be successful at the BIA before having to go to the appellate courts, which is the last resource in those cases. But unfortunately, what we're seeing, especially in the last year and a half, is a real decline in independence from the BIA. And what that means for practitioners is you now need to begin to try that case in immigration court as though it was an appellate case from the jump, because we need to explore each and every one of the remedies in these cases at the immigration court level, because we know that by the time we get to the BIA, we are not going to get a decision that's going to be much different from that denial that the immigration judge gave us. And we're going to have to take it up to the circuit courts for judicial review. So those cases are incredibly complex. They take a lot of time, energy, and attention from practitioners. But oftentimes for our clients, it's the only way that we can achieve some level of justice in those cases when the courts, especially the immigration judges and then the BIA, deny those cases. So getting those cases ready for appellate review means a thorough record. We want to make sure that we're developing those cases, each one of the arguments before the immigration judge, making sure that we don't leave any stone unturned when we're at the immigration court level, and then keep going up the chain of command.
Right. We got a question here, which we probably should address now because I think maybe all of you have some insights. The question is, where should a non-immigration attorney begin in offering immigration-related assistance, given the fluid and changing nature of the law? Through legal aid organizations, bar associations, or within their own practice? So Eric, can you answer that question to the best of your ability?
Of course. So I think there's so many opportunities now to make a difference. I think, Lourdes, what you were talking about earlier, going through the immigration court and shadowing through the ABA's program, I think this is a great example of how people who genuinely care about justice and due process can get involved and make a difference. If you want to take on pro bono cases, that's a great way to do it. If you want to take on an asylum case or an SIJS case, especially a lot of pro bono organizations and nonprofit organizations too, take on SIJ cases because you can make a real big difference for a kid who's here, who's been abandoned by mom or dad. And so fighting a case before the court is always good. It's important. Taking on an affirmative asylum case, even at USCIS, there's so many ways that anybody who genuinely wants to make a difference can go ahead and do that. Sometimes it means a pro bono case or working with a nonprofit organization. There are really no wrong answers because we are seeing so much injustice at every step along the way in our immigration system right now, that anybody who wants to do good and get involved should find whatever avenue works best for them and whatever they can do to do that.
And I should say, so for example, I am the pro bono chair of the Military Spouse JD Network. And one of our initiatives right now is to train our members who are military spouses that have law degrees but may not be practicing because they have to move from base to base, to train them in immigration law and through an organization or a law firm, the tutelage of a law firm that knows immigration, that we can, assist you guys in the work that you're doing. So there are many, many ways to get involved. And I think people are really interested in doing so. Anit and Emily, let's start with Anit. Do you have any other ideas on how people that are attorneys that are non-immigration lawyers can get involved?
As you said, most of the nonprofit organizations are in need of attorneys to help the pro bono cases. And I think that would be one of the most wonderful ways to learn and to help at the same time.
Right. Okay. Emily?
Yes, and apologies for my typing, everyone. I'm being tech support over here a little bit, so on the back end. A great way is if you speak two languages, and you can be an interpreter, or if you don't want to hear my spoken French because it sounds like Spanish, but I can read and write a lot better than I can speak it. So if you're a lot better at reading and writing a language, you could offer free services for translation of documents. Going back on what Eric said, for helping SIDGE kids, the big part of a SIDGE case is translating the birth certificate. That's the first thing we do. And so, if we're paying a translation company, whatever it is, $50, $75, $30, whatever the number is, you're now saving that kid some money from having to do that. And also, if you can provide that service to a nonprofit, it can help their backlog because it can just be done faster, so they don't have to deal with logistics of payment, et cetera. So it may seem like a small task, but it actually that's huge and is a big help. And then I would say even just supporting people. So I see a lot, you have to be careful the fine line between giving legal advice and giving, if you're not authorized to, or giving, if you're not an immigration attorney and this isn't your area and you're giving advice that maybe is not your expertise. But a lot of times, I find that people just, a big part of these cases, I think we're all talking about how long they go on, how complicated they are for detained work, how quickly you have to get documents together. Having somebody in the community who can support you, letters of support, helping somebody collect those. It's, if your family member is detained, you're navigating the emotions of having a family member detained. Maybe that person is the breadwinner of your family, and your family now has financial stress, emotional stress. And on top of that, you're having to work with an attorney very quickly. And so if you have somebody in your house, kitchen table, and they're running the command and they're saying, all right, we're going to get meals coming to the home. We're going to get the kids to school. We're going to make sure that the partner of the person who's detained is sleeping and eating. And, we can help with attorneys as the attorney thinks is appropriate, even if it's just collecting, say, letters from community members. So there are ways to just think of other crises that people go through and the support that they need, and then translate that to the immigration context. And I think that can really make a huge difference for what a lot of people, unfortunately, are up against these days with this administration.
Okay, great. So moving on to something that I think is near and dear to all of our hearts, um, which is innovation and access to justice, and the role of AI. And I want each of you to talk a little bit about this and how you are sort of integrating new technologies to your practice to make your practice more efficient. And I think one of the very interesting things that AI can now do, and Emily, you touched upon this, which are translation services. Um, we should always caveat that the use of any artificial intelligence tool does not remove the duty of counsel to review the output, to supervise those that are using generative AI, the rule of competence 1.1, the rule of supervision 5.3 under the model rules that have been adopted by 42 states plus Puerto Rico apply here. So everything that we're going to talk about AI right now should be heard under those caveats because I think they're very important. But from where I sit and the work that we're doing with law firms in terms of preparing them to the new era of law with AI technology. Everyone is really interested. And if implemented properly, and if you know which tools to use, and I want to get a little bit into that as well, I think that a lot of benefits can be gained when you do that. So, Anit, I think I'll start with you. What have you seen in your own practice that has been improved with generative AI or the new technologies that you guys may be implementing? And what are your sort of like, tips to practitioners out there relating to the use of AI?
Sure. As a new law firm, I wanted to start having a case management system that integrates AI. And I think it is wonderful because it saves time, and not only saves time to your paralegal, saves time to you, but this particular case management system has its own AI. And you can ask, sorry, you can ask information, you can ask within the same project, you can ask, and you will get information from documents in the same project. Project means the file, the case, the matter, and it will help you to save time when you are researching. You don't have to go over all the documents to find out which document you're looking for. And but when you are creating forms for USCIS, it is very helpful because the information is right there. It stayed that right there. And when you have to do more forms for the same client, there's some information that was still there, and your paralegal doesn't have to type that again. So I think it is wonderful when we have first a case management system which uses AI, because it helps. And on the other hand, it is within your environment, within your license. That means that you're protecting your client's information. It is private. And this is very important. AI is a game changer. However, we as attorneys, we have to be very, very responsible when using AI. We cannot be sharing information about our clients just to get to draft a motion or just to draft a cover letter, using different platforms without the right license, without the right security, because that's our responsibility. And in my case, we use, and we've been working with Cara Legal and since the beginning, and we use AI and automation for intakes, for scheduling. We're more efficient when using that type of scheduling systems. Now there's screening questions. You will save time as an attorney when you're doing your intake because you have screening questions, because you have information before you see the client or the potential new client. You see that information and it will save you time. So when we discuss the case or the background or all questions with the potential new client, we already know what we're going to say because we have most of the information that we need. And that comes from the screening process, from the automation, from the scheduling process, which is wonderful. And so, in my opinion, when it comes to operations in a law firm, the use of AI is just wonderful. It is just, we have to be responsible and we cannot rely only in AI. We have to understand that we are attorneys and the responsibilities on us. And look, when it comes to legal judgment, it's just us. This legal strategy has to be us. And you can get information from these different AI platforms, but it is our responsibility to make sure that the information is accurate. Cases, case law, that's our responsibility. We cannot just be drafting motions without the legal strategy, without the supervision. We have to review everything. But definitely, it is a great tool that will change the law practice.
Eric, are you guys using generative AI specifically in your firm? And have you seen like how it improves or not?
Yeah, I mean, and he'd mentioned so many of the great tools, right, that AI already has, and you can see how many more there are, right? For you can take notes of client communication and client interactions, especially when you're preparing for an individual hearing. You can take notes that then translate into a declaration, and then you can have a lot of that work already done before you go back to the client to review it and read it and go forward from there. You can put cases out that you're preparing for an individual hearing and put an entire supplemental filing before the court, and then you can ask the AI to help you put together a timeline for the client so that it's fact specific and search the documents. You can go forward on an appellate case and go for put the entire case on there and then ask it to give you not just a timeline, but a procedural history, which can help you tremendously when you're briefing it. So it's the time now to embrace any kind of measure, especially those of us who either own our firms like Anita and Emily or manage a large group of people like I do, is focusing on efficiency and focusing on ways to get people to do things in a way that's highly, not just time saving, but highly accurate. And that's really what AI has helped us do, over the last couple of years. And we're just at the precipice now of where we're going. And so I think the world is really going to change tremendously. And I think we're at the forefront of that in immigration.
I agree with that. And I wanted to point out, because I know personally that both the systems that Anit is using and Eric, the ones that you're probably using as well, and Emily will share her views of the world in a minute, but they're secure platforms. And I think I want to once again emphasize that not only do we need to educate ourselves and our legal professionals, not only the attorneys, but everyone in our law firm within our supervision, that it is not okay to use publicly available ChatGPT, Claude, what have you, and insert confidential information. It is not okay to use a publicly available note-taking system because that can waive work product and attorney-client privilege. And we are seeing already cases in New York, Illinois, and Texas basically saying that attorneys that are using publicly available tools, that those prompts and those conversations can become discoverable. So, I mean, this is a topic for a whole nother ABA discussion, but there are intricacies with the way that generative AI works that are both a game changer for the positive and a huge risk and compliance risk for attorneys on the negative side of it. But one of the things that I think that availing yourself with artificial intelligence tools can help you do, and those organizations that are doing this pro bono or nonprofit organizations, is that it can greatly expand access to justice. And I think without really understanding both the good and the bad, you can really deploy artificial intelligence effectively. But I think one of the most promising things that I think we are to see with the use of generative artificial intelligence tools is an expansion in access to justice. And I think that is a very sort of positive change. And just as an aside, what I think is relevant to any lawyer listening to this webinar, Claude, which we all know is an Anthropic tool, just launched earlier this week Claude for Legal, which has a lot of new use cases and workflows already packaged for attorneys. So if you release your own enterprise version of Claude, you can gain a lot of the same efficiencies that you're gaining paying paid subscription through a much lower entry point in terms of cost. And I think it's just, a very exciting new development in legal just happened this very week. All right, so going to you, Emily, because I know this is also an area that you do a lot of work in. How do you see artificial intelligence improving access to justice, and what are your own takes on that?
Yeah, I mean, I think exactly what you said. So well said. I think that, there's a lot here. I think looking at so I'll take a different angle on the access to justice side. It's something I've been thinking about a lot and teaching this semester and seeing that it feels like yesterday, but the time that's gone by between when I was in law school and students now and what they're navigating and all the changes is thinking about how it's going to help young lawyers or new lawyers. Or, hey, if you're watching this today and you say, I want to get involved in immigration law more, I want to help more. But 20 years ago, I know it was a whole different ball game, but getting that information, you got to get CURS bans and you still should get CURS bans, but, or CURS ban, right? But it's easier to get information now as long as you're using reliable sources. So thinking about helping. So if a lawyer today says, I want to start working on a citizenship application to help someone, I think that's a good start, assuming no complicated issues, and you want to read about it and learn about it. If you have a reputable source, you're going to be able to get more information without maybe having to commit to a bar association yet. I think eventually you should, but just to kind of get your bearings and figure things out. So thinking about it on the lawyer side, to help lawyers become more informed and navigate and open up this world to more people, and just the amount of information that's available now, I think is huge. But I do think it's a huge change. It's very interesting to see on the client side as well. It's a great topic because just yesterday, and I've been waiting to tell somebody this, and I get to tell all of you for the first time, I caught my first client using AI to email me. And I have empathy for her because I think she was very nervous emailing with me, and she doesn't need to be, but I wanted the email to be very formal. And the top of the email said, here's a polished version of your email. And I realized, and I'm going to talk to her and say, like, careful what you're putting in there, but that's a story for another day. But it was interesting to be on the receiving end of somebody using Gen AI to communicate with me. And I had to stop for a minute and think about, like, why is she doing this? How can I help her and support her? So if she wants to speak to me in shorthand, it's fine. But that was very interesting. And I thought about too, it was very good that this client reached out to me and opened up to me about something that I can now help her with because she told me. And I'm thinking maybe because she had whatever she was using, she felt more confident to email me, because I could tell she wanted to be respectful and acknowledge X, Y, and Z, but still get some help. And so maybe that tool was the assistant, the support, that she needed to help her navigate what to her, I'm sure is, I don't want it to be, but an intimidating legal process, including communicating with a lawyer. So that was just very interesting. And I guess that's a different take on access to justice. But if this client didn't reach out to me, things may not have went well, and now I can help her because we caught it early, right? More of a medical term, but it applies to in my world. So I think it's great. I think it's a great time. All of the warnings that were given today are excellent. You have to be very careful, and with every change and evolution and benefit we have, there's the flip side. And so just being careful what you use, if it sounds too good to be true, and don't, if you're just starting to learn this world, I wouldn't go in full speed unless you have somebody who's helping you navigate it, who knows this professionally, so you don't get into trouble, because that's the last thing we want.
As you were talking about your experience with your client, it brought to mind what we have seen just recently and the controversy between the different district courts, in New York versus Illinois versus Colorado, I think was the third one. And I think educating our clients, our potential clients, our audience, generally speaking, I know that some of you, I know you have a radio show every week. I think educating our listeners and our potential clients, and if we go to events, et cetera, on this particular subject is very important, because there are so many immigration cases, and I don't think that government attorneys really have the time to ask for extensive discovery, et cetera. But there is a risk of a pro se client or a client before they retain an attorney using publicly available tools, entering into those tools information that can come to bite them later because they're not aware that this is not, a private conversation that you're having with ChatGPT or with Claude. And I think we all need general education on this issue. I mean, the case out of the Southern District of New York was a sophisticated client, and they were using, a version of a public LLM before they retained a client, entering, what if I did this? What if I did that? What if I changed the fact pattern to this? And that all became discoverable because the judge said, you did not do this with a closed system, secure system, and you did not do this under the supervision of a lawyer or the request of a lawyer. So tough luck, you have to produce all of that. So educating, I think, is one of the main things that we need to do when it comes to generative AI, for sure. All right, we have probably about 20 minutes or so left, and there are a few questions that I want to get through before I ask all of you for your takeaways before we end. So this is the one question that we received here, which I think is a good question. We keep hearing about the systemic pressures on our clients. What about you guys, the practitioners? I mean, how are you feeling the stress level, and how are you coping with that now in a way that may not have been the same a couple of years ago, since all of you have been in the space for well over a decade? Eric, this is kind of a empathy question, but how is it affecting you?
I think that it's an incredibly important question, because what we've seen over the last year and a half is a lot of people who normally would have gone into immigration not go into immigration out of law school or transition from a different profession because of how difficult it can be and how difficult it can be on us. I think it's incredibly important, like with anything else in life, especially as we're practicing law, that we take care of ourselves too. We can't be the right advocates for our clients if we're not taking care of our mental health. And so that's incredibly important. It's incredibly important to find the space to talk through these cases. One of the things that I always offer any of our attorneys at the firm is when you're going to court, let's soundboard these things beforehand so you know not just what to expect, but you can talk through the case beforehand with either me or one of the supervising attorneys. But after especially is important too. If you have a really tough case and you lose, talk about it right away. Find somebody who you can soundboard these things with, or you can shout at the other end of the phone to with the injustice that you just witnessed at the immigration court. And so those things can be really important to help make sure that we're taking care of our own mental health, that we're taking care of our own well-being, so that we can continue to be really good, thoughtful, thorough advocates, because the fight is not over. We've only been through this now for a year and a half. We still have some more fight to go before we can finally hang this up and see that light at the end of the tunnel. So it's going to take a while, but even more important to ensure that we take care of ourselves, that we know why we're doing this. And I think that purpose-driven advocacy is really important, and it helps push through some of these injustices that we're seeing when we know why we're in the fight. And that's really a big part of what we're doing now too.
That's great. Anit, how about you?
Yeah, it has been very overwhelming. As Eric said, it's been only 1 year and a half. For me, I feel like it's been forever. But for immigration attorneys who really care, we do care for our clients, and more than overwhelming, sometimes it's just that feeling of emotionally speaking, feeling powerless sometimes, because you are trying to help, you're trying to do your best, you're using your knowledge, you're using your team, you're using everything you have to help a client. Sometimes it is very frustrating getting an adverse decision when it was different in the past.
Right.
It was totally different in the past. And sometimes I have clients with very special situations. For example, kids suffering with cancer, and then you file a motion for continuance just because this little kid needs treatment, and you're not trying to delay the process. You're just trying to provide more time to this kid. And then you appear in court, and this happened to me recently. I want to share this with you guys. I went to court for this case. I talked to the government's counsel. He agreed to the continuance, but he said, I cannot say that for the record. So I'm going to defer to the court. I was like, okay, so let's do it. We talked to the judge. He said, we defer to the court. And what was incredibly, for me, was very understandable was the judge said, just give me 1 minute. And she stepped out. She came back 5 minutes later, and she said, unfortunately, this is not a good cause for a continuance, and we're moving forward with the hearing.
What happened?
I'm pretty sure the judge was asking permission. They're afraid. They are afraid of making a decision, and this is frustrating because they don't have discretion anymore. And in the past, I'm pretty sure the continuance was granted, would be granted, but now they're afraid to make a decision because they cannot make decisions in favor of immigrants. And
Okay,
this
so
is
that's I want you to dive into that a little bit deeper, because we did not discuss that before, and I think is important. Are you referring to new judges and a whole bunch of new judges that have been appointed to deal with backlog and other issues that may not have immigration experience? And or are you referring to, the orders from up above that they're following through with, or both?
I would say both. I would say new judges that don't have experience, but mainly it's just instructions. They're getting instructions, and we have seen like when there's a stay for any decision nationwide, and then they get different instructions. No, you're right. You're bound by this decision and not up for that stay. And I believe this is the government has fired more than 100 judges. They don't want to lose their jobs. And I have seen in my experience, I don't know in Florida, I don't know in Boston, but I have seen respectful judges making wrong decisions that I'm pretty sure it would have been different in the past, like 2 years ago.
That is frustrating. And that's not
It
good
is.
for
It is
mental health
really
either.
very frustrating. And going back to the first question, that's overwhelming for us as practitioners because we're doing the right thing and we know what to do. But no matter what, you're getting a no as a
Right.
response. And that's very frustrating.
The goalpost is being moved at all times. That I imagine that will be an extremely difficult situation. Eric, do you want to talk a little bit about the judges, new judges, your experiences, how the judges now may be ruling differently from how they were in the past?
Yeah, I mean, I think the reality is that there was a thin veil of justice in our immigration system for a very long time that has been ripped apart in the last year and a half, you know, and that's a sad reality. We're seeing a lot of judges who are being appointed. A lot of them are being reassigned with no control of their own. They're being told to go to immigration court now and now start hearing immigration cases where they don't have the appropriate training from the immigration court, from the Executive Office of Immigration Review. They've never touched an immigration case in the past. They're expert, well-to-do people in their own field, but have no basis to try an immigration case and be called Your Honor in an immigration court, you know? And we're seeing that at every level. We're seeing these judges now assigned an increasing volume in multiple jurisdictions all over the country. And then we're seeing that compound with the issue that Andy was mentioning before, where we're getting mandates from the court staff. They're being told, the judges are being told, these are things that you cannot do. I'm surprised that a lot of these courts and cases have been granted, as we've still been seeing cases get granted across the country, because they are being pushed to deny. And I think that's a sad reality that we have to live with. But how we can balance that is our purpose, our mission, our objective here, which is to ensure that our clients have equal access to justice in a very unjust system where a lot of them are going uphill, not just with the nature of the process and the nature of these claims, but with the fact that we're getting people now making decisions who are very good lawyers at what they do, but they're not immigration judges and they're not immigration lawyers. And that's the reality of our current system. And that can be incredibly frustrating as we practice.
I believe you. I am getting stressed just listening to you guys. Emily, why don't you share your views on our new judicial system as it relates to immigration, and also answer this question that we received, which is, how can we help? Where do we go?
Well, I think to follow up from the conversation, I think this shows us why now more than ever having an Article 3 court is so important. So for those who aren't immigration lawyers, the immigration court is not an independent court. And you know, exactly as Anit and Eric were talking about, spot on. It's let me get off the bench for 5 minutes and possibly make a phone call if that's, you know, it sounds like that's what happened. Which, you know, when I'm in state court, if that happens, it's probably the judges looking up a case, right? And so there's independence for the judiciary, which is so important. And I think, and it goes to the heart of, this has always been one of the topics I'm passionate about, is that, you know, we treat immigration law is civil in nature, it's administrative law. And so it functions as an administrative system. So there's supposed to be procedural due process. There doesn't have to be substantive due process. So that's why I just had somebody ask me this. This is why you have a right to an attorney, but if you can't afford one, well, then the government is not going to appoint one, like we know exists in the criminal system. And so, okay, so we have that. But the problem is the system in a lot of ways looks like a criminal system. We're putting people, we say detention centers, it's jail. And a lot of times it's worse than jail. I go to jail all the time for people serving criminal sentences. And there are more programs and support. I'm not an expert on detention centers across the US, but from what I've seen from my own clients and heard and what we're all reading in the newspaper every day, it's deplorable what's going on at many, most all fill-in, detention centers. And so we are criminalizing the immigration system and oftentimes treating people as though they're criminal defendants, but yet we're not providing those protections. And one of those protections that if you're going to treat people this way and hold them to this standard where you take away their liberty, take them away from their family, and a lot of times this can be life or death in an asylum case, withholding case, CAT case. Somebody goes to a country where they can't support themselves. We're holding people to all of these standards and yet not giving them the protections that we ensure somebody who is charged with a larceny under 1,200 for shoplifting from CVS. Yes, I have cases like that. And I'm not saying take away my shoplifting from CVS, alleged shoplifting clients' constitutional rights. I'm saying give people more constitutional rights, including Article 3 court. So that's my whole, this is one of the many reasons we're here. There's many reasons. It's incredibly complicated. But this is one of the fundamental problems that you can have amazing lawyers, Anid and Eric, who are in court and appealing and fighting every day. And yet the system is broken. And I will say, in my opinion, it's fundamentally constitutionally unfair.
Thank you.
I know there's a question in the chat too. I was supposed to answer.
There is a question about perhaps getting a QR code or a link, but I want to say how incredible it is to listen to all of you and the passion in your voices, and what you do is amazing, and hopefully it will inspire others to do the same. I think for the audience, we will add a link or a QR code that you can go if you want to volunteer or learn more. But I would love for Emily and Eric and Anid, we have about 8 minutes left, for each of you to take a couple of minutes and give us your takeaway for the audience today. Eric, let's start with you.
I think that the biggest thing is to get in a fight. There's a lot of injustice. There's a lot of things going on in our immigration system that make things incredibly challenging for us as practitioners and for our clients. But now is not the time to give up, and now is not the time to get unmotivated. It's the time to rise to what the clients need, to be advocates like we really, truly, a lot of us went to law school to do. This is the time to do it. So as difficult as it may be in our immigration system, as challenging as it's going to be to practice immigration law every day, this is the time to stay involved and get involved if you haven't been, because the injustices here are great, but the justice that can come out of that and that we can make sure that our system does for our clients and for every immigrant across the country is very wide. And we have the ability to do that at our fingertips by fighting these cases in court, by fighting them at the appellate courts, by filing cases at the district court and pushing them up. We're all well trained to do that in our own capacity and in our own way. And now is the time. So get involved, fight, and get ready, because we need, our clients need us, and we need to continue to fight stronger and stronger every day.
And along those lines, Eric, I think it would be a very good idea, and I'm sure that a lot of you already do that, to go as an immigration managing partner of a firm, to go into the law schools and to talk to the students and to inspire the new generation, because yes, we have difficulties with this administration, but we don't know what the next administration is going to be. There will always be immigration issues to tackle. And I do think that we need more of you going into our law schools and talking to people about the importance of doing this either as a full-time job or as a pro bono practice to their day-to-day work. But I think going into law school, the same thing that I say to people talking about, us that are in the AI space, one of the most important things that we've been able to do over the last 2 years, it's get in front of the law schools and get in front of the lawyers to encourage them to use it, to not be afraid, to explain to them what it is and what it is not. And I think the same sort of idea applies to immigration lawyers. Anit, final takeaways for the audience in terms of what you see as relevant, important issues right now?
I think that the best way to express this is like Eric said, don't give up. I think there's an immigrant community that needs us, and this is the time for the fight. This is the time when we must go to court and fight for our clients. Fill up that record for an appeal if you have to, but never give up. And in terms of education, not only law school students. I recently went to Florida State University. I was invited by a group, pre-law students, and they were so interested in immigration. And we had a wonderful night, and we talked even about AI. One of them just gave me a book about AI, and they're already reading about it. It is so important for the new attorneys, for the new young people who wants to become an attorney. They need to understand the fight. They need to understand the community, the immigrant community. This is not the typical client. I mean, every client is different for practice, right? With immigration, it's different. You got to be empathetic with them. You need to understand them. You need to make them feel protected. You make them feel respected, right? They have rights, and we are here to fight for them. So even when things are going crazy right now, please don't give up.
Thank you. Emily, take us home. We have a couple of minutes left.
Right. Thank you. I just wanted to say, for those who want to volunteer with the Commission on Immigration's Court Observation Awareness Project, we don't have a chat for this, but in the Q&A, I believe it's Fabiana was kind enough. She said she wanted to volunteer. So I dropped the link where you can read about the volunteer project and sign up. And that's also in the PDF that was sent out. And I also wanted to give a shout out to, I think it's Mr. Thompson, for your points about Gen AI. And yes, it's an interesting time. So check that out if you want to see what Mr. Thompson had to say. So yeah, I think my take is, in my inspo piece, is elections matter. Unfortunately, we're seeing that. We're living that. We're feeling that. We're breathing it. We can't go back in time, but we can use it as a lesson. We have some days I want to do the math and some days I don't, depending on how full my tank is. So I just won't say it right now in case it stresses anyone out. But, we have a lot of time, and yet we don't have a lot of time. I mean, midterms are coming up, as we know. And then, things will be live. And I would say presidential elections clearly matter, but local elections matter as well. Congressional elections matter. And so if you can or don't want to get involved in directly helping an immigration client, get involved in policy, get involved in elections. Even if you volunteer at a fundraising event for a candidate and you're handing out pizza, I mean, everything matters. And there's clearly consequences, and these are people's lives. lives. This country, my grandparents came here, and my great grandparents and all of us, we all have an immigration story, one way or another, or our own immigration story. And this country welcomed in my family years ago, and things were very different then, and it was a lot easier than it is now. And so I encourage people who are maybe a few generations behind, farther from their immigration story, to remember that, someone opened up their arms at Ellis Island for your family so that your feet touch U.S. soil every day. And if it's that you immigrated to the U.S. or your parents, et cetera, just remember, everyone has a story, everyone has a reason, and that's what the United States is. And is this the legacy we want to leave? I mean, I think we're all here, and we're all allies and supporters, but even being in that space, how can we have what we have today? What can we control today that can hopefully make things better for tomorrow? And even if hopefully the administration changes, things get better, the cleanup efforts and the trauma, and I think about the children and the trauma that they'll endure from what they've witnessed their parents go through and their aunties and their uncles and what those parents, et cetera. So just be kind to people, try and remember where your family came from, your story, be supportive. And if you can do one good thing to support somebody, particularly our friends in the immigrant communities, then you had a great day, and you helped make the country a better place while we're navigating incredible hardship and difficulties. And every day is a new day, and please vote. Elections definitely matter.
Thank you. Thank you to the ABA. Thank you to our panelists. It was an amazing conversation. And get in touch with the ABA Commission if you want to volunteer. Thanks, everyone.